Hello again, my name is Mark Silver. I'm a forensic psychiatric social worker. I'm a mitigation expert in New York, and I'm presenting a series of YouTube videos. These videos are based on multiple CLEs that I've done for criminal defense lawyers in the United States. The difference is I'm putting them on YouTube so they're free and available to everyone. As I said, I am a criminal mitigation expert. I am a psychiatric social worker with a doctorate in psychology. I'm also a lawyer. To the embarrassment of my mother, I don't practice law. I have a background also in family systems therapy and political science. The first program I did for YouTube for criminal defense lawyers was a general overview of criminal mitigation, but it was also for lawyers who are quite experienced, and I'm trying to provide them a new perspective on something that is what I think absolutely essential in the armamentum of criminal defense lawyers today. The topic today in criminal mitigation is white-collar criminal mitigation, and the subtitle is Sentencing in the Post-Booker Age. This is my book, Handbook of Mitigation in Criminal and Immigration Forensics. It's the 7th edition. The subtitle of the book is Humanizing the Client Towards a Better Legal Outcome. And this is the core idea that I present in all my programs: how to humanize the client, how to allow the client to be seen as a real individual and not someone who's only committed wrongdoing. And this is all the more important for white-collar clients who, quite frankly, are demonized. You know, many times these are clients who have grown up in middle-class homes and they're educated, they've been good community members, and then they commit a wrongdoing, fraud of one kind or another, which is something that we have to contend with. But we have to contend with it in the reality that, are they really being represented properly, in the sense that here's a person who's done so much good in their lives and now they've done something wrong. It needs to be balanced. We need to humanize and rethink the criminal defendant in white-collar cases so that they're not demonized, so that the biases and prejudices, the anger, the hostility by prosecutors and by the community in general is somehow removed or lessened. I really try to integrate theory with practice as much as possible. Please don't hesitate to send me an email at marksilver1cs.com. My information's on YouTube, and I'll be happy to send you back a redacted copy of a white-collar criminal mitigation sample. Clearly, redacted copies have identifying information of the clients removed. So the lawyers who will most benefit today are obviously white-collar criminal defense lawyers. Many of these cases involved, as I said, fraud, theft, failure to report. Many of these clients are in finance or banking of one kind or another, even attorneys. Some are in administrative positions. Also, clients who are from the middle class, that is, defense lawyers who tend to focus on clients who don't have a, long list of arrests on their rap sheet. In other words, clients who've generally led a healthy, safe lifestyle and get into trouble. These are also clients who may not be white-collar clients per se, but this program will hopefully address those issues. There are also ideas within white-collar criminal mitigation, which I think is applicable and helpful to criminal defense lawyers generally. And the last area of focus today for those who may benefit are lawyers who specialize in an area of professional misconduct in administrative hearings. And the reason I say that is because the commonality between those clients and white-collar clients in these kinds of cases is that both clients tend to be from middle class or upper middle class backgrounds. Both clients tend to have little or no criminal history. Both clients tend to have very little familiarity with the criminal justice system. Both clients are usually horribly traumatized, frankly, by having having the reality of facing the loss of their home and their life and their employment and so on, and really having their lives turned upside down. I give a wide range of CLEs, and I'm trying to put as many up as I can on YouTube. Today's on white collar, but I hope to put one up on inadequate PSI reports done by probation officers. I'm going to put one on complex trauma, borderline personality disorder, and other key areas that I frankly cover in my book, and that I've covered for private providers in the CLE forum. So I just want to give first a definition and overview of criminal mitigation. Mitigation is a biopsychosocial evaluation of the client's social and psychological history, informed by the facts of the criminal case with appropriate recommendations as to means to minimize the negative legal outcome either in court or with a prosecutor. So we want to get at anything and everything in the client's background to get a better legal outcome, either in court, meaning for pre-sentence purposes, or with the prosecutor, meaning for pre-plea purposes. And this is key for white collar, where there's so much bias attached to the defendant that it's very important early on to allow the prosecutor to know who this client is, not just their wrongdoing, but their history and how they got themselves into so much trouble, their judgment, decision-making, and so on. The second part of the definition is that mitigating circumstances, of course, may extenuate or reduce the degree of moral culpability or blame, which in fairness, sympathy, or mercy may lead to a more favorable outcome for the defendant. We are trying to humanize the white-collar criminal defendant because he is necessarily demonized. And we're going to look at anything and everything in the person's background. The purpose of mitigation, therefore, is to humanize the client through a sympathetic narrative, especially clients who are deemed to be very privileged, and maybe the court or the prosecutor thinks, oh, well, you should have known better. You had every opportunity in life. You're not as if you've come from an impoverished, lower socioeconomic community where you suffered abuse and so on in your family of origin. So we want to induce empathy into the reader and to document the client's life history and conduct. And in white-collar cases, you may have a client who's done a great deal of good in their life in almost every area in terms of family, community volunteer work, charitable donations, and so on. We want to contextualize the client's conduct, look at if there are any family members that would suffer severe harm, physical, psychological, other kinds of harm because of their dependence on the client. We want the client to be genuine in his contrition. That is, the remorse and regret really has to come from the heart, because, again, in so many of these cases, the white-collar criminal defendant is seen to be heartless. Professional expression can replace self-expression, meaning that, many of these clients, it's very hard for them to take a cold look at their wrongdoing because they've been quite successful until that point in their lives. Quite frankly, they may be narcissistic or even self-aggrandizing, and just as they need a criminal defense lawyer to navigate for them complex legal system, legal counseling options, and so on, they may need a forensic mitigation expert to help reflect who they are, so that not only the prosecutor and judge knows, but quite frankly, so that even the criminal defense lawyer himself gains valued insight into what makes this client tick. So it's not just a mental health report, it's something much broader, especially for white-collar cases where the criminal defendant may not have a documented history of psychiatric issues. We want to include a great deal about the person's life, and as I said, we humanize them by showing their involvement in their families, in their communities, and so on. Obviously, a great focus is the guidelines themselves. The guidelines, as we all know, replace the intermittent system that it was meant to greatly reduce judicial sentencing discretion by establishing narrow sentencing ranges based on a series of factors, including the type of offense, characteristics of the victim and offender, and obviously the criminal defendant's criminal history. The main statutes we're all familiar with: 18 U.S.C. 3553A. Factors. These factors offer an incredibly broad range of possible mitigating arguments at sentencing. And it begins with a really overarching mandate that is, court shall impose a sentence sufficient but not greater than necessary to comply with the purposes of the statute. Section 3661 notes, no limitation shall be placed on the information concerning the background, character, conduct of a person convicted of an offense which a court of the United States may receive and consider for the purpose of imposing an appropriate sentence. And the statute goes on to direct courts to consider almost anything related to the defendant and his potential punishment, looking at the nature, circumstances of the offense, the need for sentence imposed in terms of how should it reflect the seriousness of the offense to promote respect for law and to provide just punishment for the offense, to afford adequate deference to criminal conduct, to afford adequate deterrence, not deference, to criminal conduct, to protect the public from further crimes of the defendant, and to provide the defendant with needed educational or vocational training, medical care, or really any other treatment that may be necessary to effectuate a good outcome. So, in the memorandum of law presented by the lawyer for sentencing purposes, it is crucial to interweave the above criteria into key mitigation factors outlined in the mitigation report. This will truly afford the prosecutor and judge to consider and understand the client's psychosocial issues as legal mitigating factors rather than simply background information established for the sake of general argument. That is, the criminal mitigation is not simply an effective tool for the sake of argument, but a necessary legal factual underpinning to support the factors of 18 U.S.C. Section 3553A and other relevant law. One question that I've had intermittently in recent years is, must a lawyer mitigate? Obviously, I'm a criminal mitigation expert. I see it as a necessary underpinning in criminal defense today in the United States. We remember a time prior to the Gideon v. Wainwright decision of 1963, and now, we have a Supreme Court mandate that clients benefit from legal counsel for felonies. Might it not make sense to have a kind of parallel mandate for clients who've committed felonies or perhaps even misdemeanors, that they have the benefit of an assessment looking at broad issues in their psychosocial background, mental health, family, community, and so on? The fact is, that's kind of what a pre-sentence investigation is by the probation officer. And the damn problem, as we all know, is that the pre-sentence investigation reports are horribly deficient in many areas. And in fact, one of the reasons that it's so important, especially in white-collar cases, to get a criminal mitigation expert early and to get an evaluation is that before the PSR, the probation officer will have something to read that's substantive, that speaks to these areas that he will be asking the client about. We have, of course, the U.S. v. Booker case from 2005, and it stands basically for the proposition that guidelines are now effectively advisory and mitigation has found its rightful place in jurisprudence, and that the mandatory guideline system is unconstitutional. Gall v. U.S., 2007, further liberalized sentencing when the court ruled that extraordinary circumstances did not need to be present to justify a sentence outside of the guidelines range. And that's very important because, again, in white-collar cases, there may not be overtly extraordinary circumstances because very often in these white-collar cases, people have lived a rather conservative, normal, healthy life. That case also held that an appeals court could review the length of sentences only under an abuse of discretion standard. Clearly, criminal mitigation has played a crucial role. The court now has unfettered discretion to consider any and all evidence in sentencing. A wide range of arguments may now be considered and submitted at sentencing phase. The one thing I'd say, and I've mentioned this before, is that criminal mitigation, it's not magic. It needs to be utilized by the criminal defense lawyer as a complement to their own work. They need to really digest it just as we want the prosecutor and judge to digest it, know how to use it. I had a case recently, the lawyer was from California, but the case was in southern Florida. And I really did not speak with the lawyer very much during the course of the case. And I was worried that the lawyer had not really read my mitigation report fully. And yet when I saw his memorandum of law, he really expertly took bits and pieces and weaved it into his legal arguments in his memorandum of law for sentencing with regard to the client's family and her mental health issues, her background, issues related to alcoholism, all sorts of things. And it was just very smooth. In other words, there was no sense that the criminal mitigation expert had done something completely separate from the criminal defense lawyer. Obviously, it's two different expertise, two different specialties. But in a sense, you're trying to understand and advocate for the same person so that the prosecutor and judge will themselves have a much better sense of who these people are, challenges, failings, traumas, whatever issues that help inform their decision-making and judgment that got them into so much trouble. I have a bunch of quotes that I offered in my original YouTube video, but I'll mention one or two. It has been uniform and constant in the federal judicial tradition that for sentencing judge to consider every convicted person as an individual and every case as a unique study, and the failings that sometimes mitigate, sometimes magnify the crime and the punishment to ensue. That's from Justice Kennedy. District courts should not hesitate to use their discretion in devising sentences that provide individualized justice. That's U.S. v. Williams. It's a 95 case. And, one of the problems is that in white-collar cases, the community, prosecutors, they may have a tendency to see the criminal defendants as uniform. And we see this in other areas also, right? I mean, there's a drug arrest. There's a criminal defendant who sold drugs. Oh, it's just another drug bust. It's just another person who sold drugs. But as a human being, they've gotten there for a reason. And we need to know what those reasons are if we're going to really have and instill integrity into the criminal justice system. An interesting case I'm sure everybody's aware of, Pepper v. U.S. from 2011. In determining the sentence to impose, the court may consider without limitation any information concerning the background, character, and conduct of the defendant. One of my favorite quotes, if the 600 plus pages of the most recent set of sentencing guidelines have taught us anything, it is that punishment cannot be reduced to an algorithm. That's U.S. v. Myers. It's a 2005 case. Surely, if every man is to receive credit for the good he has done and his immediate misconduct assessed in the conduct of his overall life, it should be at the moment of his sentencing when his very future hangs in the balance. This elementary principle of weighing the good with the bad, which is basic to all great religions, moral philosophies, and justice systems, was plainly what Congress had in mind when it directed the courts to consider as a necessary sentencing factor the history and characteristics of the defendant. U.S. v. Ailson, it's a New York case from 2006. So there are a couple special issues here with white-collar cases. And the first is, as I mentioned before, there's a great deal of bias and prejudice. Someone walks into the court with a $2,000 Giorgio Armani suit, they are perceived in a particular way, just as there's bias and prejudice in the courtroom because of a person's gender or their hairstyle, their clothing, their skin color, and so on. There are false presumptions often in these kinds of cases about wealth. I had a lawyer who committed fraud through his practice, personal injury lawyer, about 2 years ago, I'd say. And, I also, before I saw the case, I thought, this guy is doing rather well. But with his expenses and everything else as a personal injury lawyer, he was making a rather modest living. But there's often jealousy, hostility, and anger by the prosecutor's office. They may feel that they've done something unforgivable, the criminal defendant. And I got to tell you, I see this as a parallel in sex cases where the person is so demonized, there's some view on the part of the community or the prosecutor that they're unredeemable, that there's nothing that can redirect them towards a healthy pathway. And it's unfortunate that people really that have strived, throughout their lives toward educational excellence and hard work are so terribly penalized for their transgressions without regard for the excellent citizenship, community volunteer work, and so on that the person has provided until that point. We want to show that the person is not evil. We want to explain how the person has been misdirected and what their misjudgment has been based on. One huge example is greed. And I had a case many years ago. This was a client who worked at a bank, and it was a fraud case. And when I interviewed him, it was incredibly surprising to find that he had taken the money and had basically given most of it away. There was a neighbor who had suffered terrible loss because of a house fire, and he gave the family quite a bit of money, I think even anonymously. He did buy a new car for himself, but really he didn't live the life of Riley. He lived a rather understated life, and he helped other people in the community. I'm not trying to justify his wrongdoing of fraud. Obviously, it's criminal, it's wrong. But it's very different, writing up a case, someone like that who's taken the money, he doesn't really need it. He, stole the money because of other reasons, self-esteem and all sorts of crazy reasons. But the outcome is not that, he spent lavishly on himself, just the opposite. He tried to help others who were less fortunate in the community. Sometimes prosecutors, and I've seen this a lot in sex cases, they have this bias that this is just the tip of the iceberg, that you have someone who's been arrested for fraud, but that white-collar defendant has committed many other wrongdoings. And I once heard this, and I was terribly angry. I once heard this from a former federal prosecutor who said, well, if we weren't exactly right in getting him for this, we know he did, 3 other bad things. There's a presumption of innocence, and there's a presumption if there are not other crimes that are documented, that they haven't occurred. And one of the ways you battle this tip of the iceberg problem is by really looking at the client's life in detail and showing that the client has in fact lived a very honorable life. And that includes, by the way, within the context of the person's wrongdoing. So for example, I had this client, the criminal defendant, who had a personal injury law practice. Yes, there was wrongdoing there, but he had also been in his law practice for some 20 years before that, and he had no wrongdoing whatsoever. He was never arrested. There were no complaints against the Bar Association. So even within the context of his wrongdoing, it's important to make clear that this is a person who perhaps until that point in time was acting in a proper manner. This is one of the reasons, they say in Chicago, vote early, vote often. I'm going to Chicago for a case tomorrow. It's so important to start very early to make sure that these kinds of biases do not come into play. I know there's a huge issue about trial penalty for white-collar criminal defendants because the cost of going to court is very, very high, and the possible outcome of being sentenced to a much higher incarceration period is very frightening. It's embarrassing to go to court. And all these issues really end up making the criminal defendant deferring to their criminal defense attorney who negotiates and bargains with the prosecutor's office, ultimately leading to a plea bargain and so on. And it's a very serious problem because in many of the white-collar cases, although they really do get better outcomes with their criminal defense attorney doing plea bargains, many of them are convinced that they did nothing wrong because it's normative or it's something that they've done for many years. And as a result, it's hard for them to seem genuinely contrite for their wrongdoing. Another major issue is that if you use criminal mitigation for the pre-plea stage, if it doesn't work out, the same report can be used, especially in white-collar cases, for pre-sentence purposes. And Another major issue in these cases is that, as I said, a client walks in with a $2,000 Giorgio Armani suit. You don't have any sense of who that client is. You just focus on the suit. I had a client who was arrested for 2 robberies in Central Park in New York. And he presented as this kid from the hood and so on. He was, in fact, a kid from a middle-class home, really upper middle class, and he went to private schools and so on. And it was so important to uncover why he had to try to adopt a different identity, why he had to try to change his persona and his dress and his culture and so on. When it was found out where he was from, there was much less sympathy for him because he came from this wealthy family. But the fact that he presented himself in such a different way than his family of origin presented himself spoke volumes of his experiences while growing up in that home. Don't assume anything, therefore, for criminal defense lawyers in white-collar cases and in middle-class cases in general. Don't assume that the person has a particular kind of background just because they're now in a white-collar job. Don't assume they've had a privileged background. Don't assume they've grown up with a white picket fence home. Don't assume that a 6-figure salary necessarily means that they're psychiatrically stable. Money is not equivalent to love in a home. An outsider may have known this person for many years and then discovers that, this person had all sorts of very personal academic or learning disorder challenges, whatever. Don't assume anything in white-collar cases about the person just because they seem put together. I had a family in Jersey. This was a mortgage fraud case. The son and father were both being prosecuted. And, the son was working with the father for many years. The father, it turned out, was an extremely controlling, manipulative individual because the father himself had suffered terrible trauma in his own family of origin. But, this was a case where the client seems so put together and normal. He lived in the suburbs in an upper middle class neighborhood, and yet he suffered from his domineering father without the ability to say no because of his childhood issues. He couldn't redirect his decisions in a normal or a healthy way, and it was a major influence in his wrongdoing. Some clients, again, who look normal may have suffered not only from personal issues, but even complex trauma. I saw a woman who was a dentist in upstate New York. She had committed fraud through prescription medication and so on. And she had really presented in a very normal and healthy way. Now, one of the reasons she did that, and this is very important in these kinds of cases, was because she herself had abused some of these drugs, and she had been clean for about a year. The cases had dragged on. And I would never have suspected before I did my clinical evaluation that this was a person who grew up in a home with a abusive, alcoholic father, where there was terrible uncertainty regarding finances, and there was repeated emotional abuse towards her mother, who's the victim of partner abuse. And this woman had grown up suffering repeated harms and abuses resulting in complex trauma, which I have a completely separate CLE on. You don't assume anything. I had another client, and I actually have a whole program on this, a woman who'd grown up in a home that was very middle class, where her father was a physician, and it seemed fine from the outside. And it came to light that her parents were Holocaust survivors, and the family had suffered horrific anti-Semitism in Eastern Europe and relocated to the United States, started their new lives as first-generation immigrants. But the traumas were intergenerational traumas, and this client that I saw had developed borderline personality disorder in reaction to her experiences in her family in origin. And she had subsequently stolen her father's prescription pad, and all sorts of problems ensued. But again, this is a case where someone had in fact grown up in what seemed to be like an upper middle class family with a father who was a physician, and yet there were very, very serious underlying problems that led to complex trauma for her. Some of these clients in white-collar criminal cases are quite new. In fact, all these clients that I see, they have not been arrested before, or if they have, it's very, very unusual, and something minor usually occurred. Some of the white-collar criminal defense clients that I see for mitigation, they can be very trusting of the system in some ways. Things have always worked out for them. They've gone to school, they have a family, they have a career, and they think, well, things have always worked out, the system's fair, and it's going to work out here too. And they're naive. They don't understand the prosecutor's power and how the prosecutor can be, quite frankly, controlling and even manipulative in his or her own way. Sometimes things don't work out. Some white-collar criminal defense lawyers pay their lawyers a small fortune. They think, well, the lawyer's going to solve my problem. I gave a lot of money. And the lawyer says, look, this is a serious matter. The law is quite clear. You've committed a wrongdoing, and we really have to be very vigilant in how we're going to approach this. The client may be quite arrogant or demanding or unapologetic. And sometimes some of these clients are frankly worse than career criminals. Similarly, for criminal mitigation purposes, some of these clients are very arrogant and demanding and unapologetic. And I've had clients who, are willing to pay, a set fee, which may be quite reasonable for the services. And yet the reality is that after doing so, they expect very little participation. In other words, the client does not want to come in for an evaluation, does not want to bring in friends or family or produce documents. And I say, how am I going to write a mitigation report if I don't do a mitigation clinical evaluation? And again, the client may sort of feel that things are just going to work out. But things don't work out. Things have to be pursued in a very professional way. And it's absolutely crucial that this is made clear to the client, both by the criminal defense lawyer and also by the criminal mitigation expert. Because if that client's not showing up for appointments, it's not going to work. It's not going to work. You need a lot of participation. Some of these criminal defendants are quite educated, and because they're quite educated and they're quite high functioning in their lives and careers, they can be quite good at hiding mental health problems, including serious mental health problems and even serious drug addictions. As I said, I had that client who was a dentist who was involved in fraud because of medication, and she would show up for work quite regularly, inebriated. But she functioned quite well in other ways, and although people in her office commented on it, she saw clients for years and ran her dental practice and had no complaints from clients. That's what's really amazing. There was no malpractice claims whatsoever throughout these years that she's drinking. So sometimes these successful clients are particularly good at hiding the issues. They may be in denial and so on. Many of these clients, therefore, if they haven't suffered trauma, they probably have undiagnosed depression, and they're contending with their depression one way or another. They're self-medicating with alcohol or drugs, or sometimes unhealthy impulsive behavior such as having a lot of sex or gambling, driving fast, and so on. And some of these clients may act impulsively within the workplace. Underneath, they're fragile and vulnerable because of their depression. You just, scratch underneath the surface and you see some of these white-collar defendants who really feel terribly insecure and unstable. But the fraud they're committing is sometimes quite self-destructive, but self-destructive specifically to contend with these mental health issues, including depression. So some of these clients will have had a history of trauma, some won't. You have to be very sensitive. It's not like a client who comes from, quite frankly, a lower middle class, impoverished neighborhood where abuse and crime and gangs and alcohol and drugs are ubiquitous. You have to be very careful about these clients and take them one at a time, not necessarily shocked if there's trauma, but also not necessarily shocked if there's no trauma. Other examples that come up with white-collar cases is ADHD. We usually think of ADHD as pertaining to children who are bouncing off the wall, but that's not true. ADHD also affects adults. Many adults are not diagnosed, or children are diagnosed very late. I just spoke to someone in my synagogue, it was very interesting, whose son, who's going into grade 12, diagnosed himself. And first the parents were kind of skeptical, and he said, well, take me to a doctor and have me evaluated. And sure enough, after this kid had done all this research on the internet, it turned out he did have ADD, attention deficit disorder. The reason that his parents didn't think he had it because he didn't have the H, he didn't have hyperactivity and impulsivity, he wasn't jumping off the walls. But ADD is a serious issue. It's a neurological issue, developmental concern, and it very much reflects how we think, how we process information, our memories, even interpersonal relationships, our focus, concentration, and so on. And it's something that needs to be considered. Another example is autism spectrum disorder. There are many people out there who have autism. They're on the spectrum, but they function in one way or another quite well, sometimes in very parochial ways, but sometimes also quite broadly in their overall functioning. And it's something that should be considered. I had many years ago a guy that owned 2 pharmacies, and his manager committed terrible fraud, and he had replaced medications and he had forged prescription medication. And I kept asking my client who owned these pharmacies, like, why are you letting this guy do this? And he was already arrested once, and there was a second arrest, and my client who owns the pharmacy was, of course, in deep trouble. And it became clear that he had autism, and he just didn't have the ability to confront his manager. He didn't have, the emotional wherewithal. He didn't have the interpersonal skills. And that's why this is a guy who did management for the pharmacies and owned them, didn't work with customers, didn't work behind the cash register, and so on. And, it was quite sympathetic to understand that his limited communication skills, his limited ability to understand how people function interpersonally and so on, got him into trouble, and it was helpful for the case and helpful for the lawyer who had, no idea. She just couldn't understand how her client had gotten into so much trouble. In white-collar cases, I also see undiagnosed alcohol addiction. In the old days, you used to see these cases where executives would have booze in their office, maybe they still do, and clients would come in and they'd have a drink, and they'd have a drink with colleagues. And this was alcoholism. This was an individual who was reinforcing their alcohol needs by having a drink every hour or 2 or 3, whatever it was, but in a way and in a context that seemed professionally appropriate, because he wasn't trying to drink alone or sneaking drinks in the corner of his office, but rather with colleagues. And, you see this with clients that would go out for, a 2 or 3 hour lunch with, 4 or 5 martinis. Some of these clients were clearly infusing their alcohol problem into their professional lifestyle, and it helped cover it. It helped them to minimize it. It could have been self-medication because of other issues such as depression. It's not clear, but it's important to find out about this. I had a white-collar case of fraud, where the client drank exclusively in his bedroom with his wife from about 12 midnight to 6 a.m. in the morning. His children, and 2 of them were young adults, had no clue about the father's alcoholism. It was a codependent relationship with the defendant and his wife. His wife helped cover up her husband's alcoholism. And so there are many cases in white-collar work where either through the office or in more narrow settings, the addiction can be covered, and yet the person continues to function. There are key ideas in white-collar mitigation. I've noted this in other CLEs, but is this an aberrant decision? Is it misguided behavior? Is it just a foolish error in judgment? And I say that particularly in white-collar cases because you have individuals who've not previously had a history of criminal misconduct. Have there been life stressors over several months or even several years or even since childhood, which in a sense added to diminished capacity that led the person to act in an unthinking moment? And I always clarify, when I say diminished capacity, I know criminal lawyers always jump to psychosis, schizophrenia, diminished capacity as a full defense in a criminal case. But really, when I say diminished capacity, I mean, is the person's ability to make decisions and their judgment lessened because of these multiple stressors over many years? With white-collar defendants, this is really important. We want to emphasize, if at all possible, that the client is not evil. they've committed wrongdoing, but there's a reason, there's a context. This is not a career criminal. Some clients who are older, I have found in criminal defense work, that are more isolated, have undiagnosed depression, and some of them really have no animus toward the workplace or society, but they've done their wrongdoing. They feel they're not heard. They feel that they've worked in a place for many, many years and they've not gotten sufficient recognition for their accomplishments and so on, and that they have ultimately a gripe with their boss or with the corporation, and they commit this wrongdoing. It's obviously very serious, but it needs to be understood in context. As I said earlier, some of the clients I see are really bewildered. Sometimes the criminal statute is overly complicated and frustration ensues. Sometimes even for the prosecutor doesn't fully understand the client's conduct within the context of the statute. Clients may view the illegal behavior as normative or routine among his peers in the white-collar world. And also sometimes there's a complex set of facts that I find sometimes very, very, very difficult to follow. And it can be very helpful to narrow those facts in a way that provide a simple narrative of what occurred, even though it could be indeed quite complex. Some clients feel railroaded because they don't understand what's at hand. I had a client many, many years ago who felt railroaded. He didn't understand the statute. He said, oh, this is what everybody in my workplace was doing, my colleagues. And he had, a very supportive wife who also was kind of suspicious and guarded. And she was really supporting him in this crazy idea that he did not commit any wrong. And therefore, his ability to fully participate in the mitigation evaluation and assist his lawyer was really in some ways undermined. I guess I should mention that there are certain character types you see with white-collar criminal issues you don't tend to see as often with other kinds of criminal defendants. One is dependent type. These are clients who have difficulty making everyday decisions. They need others to assume responsibility for them. They have difficulty expressing disagreement. They may feel uncomfortable or helpless when they're alone. And these clients may unconsciously try to turn the lawyer into a parent, bring into the office insatiable needs for the affection and attention, and they may become hostile and sulky when the needs are not met by the lawyer. These are very important to understand because these are the kinds of clients that end up, lodging complaints against the lawyer. These are the kinds of clients that walk away and have 3 or 4 different criminal defense lawyers before sentencing. These are clients that tend to be chronically unhappy. Another personality type is borderline personality disorder. I won't go into detail. I have a completely different program on this. But these clients really feel ignored, unheard, misunderstood. They have chronic dissatisfaction with everybody in life. They may feel very abandoned so that they become very clingy. There's blurred boundaries with the criminal defense lawyer and his office, which can be very, very disheartening. The borderline will often see things as, in very stark contrast, so that at the beginning when the lawyer's hired, the borderline may say, oh, you're the best lawyer in the world, you're giving great advice, I'm so happy, I feel great. A month later, 1 or 2 phone calls aren't returned by the criminal defense lawyer because he's busy on trial with a case, and the borderline stomps into the office. I hate you, you're the worst lawyer, you get demonized, you're verbally assaulted and emotionally assaulted and so on. And these are very self-destructive individuals. They may sabotage their own case, even with really good advice, and many of these clients end up having multiple lawyers. Some character types in white-collar cases can be very controlling, very obsessional. They can be quite preoccupied with details and rules. They can demonstrate perfectionism. They're unable to separate in a case what's really valuable from what's not. Like, in cases you have a lot of information, but you want to be able to compare and contrast that information, to understand what needs to be presented to the prosecutor and how, which is true in a criminal mitigation case as well. You don't write 1,000 pages, you write 20 pages or whatever. You narrow it down, and the controlling character may want to include everything. They may be quite rigid and stubborn and quite obsessional. They may also be quite miserly. They don't want to continue payment. And such clients may become so consumed with the unhelpful details of the case that the client prevents the mitigation expert from moving forward with substantive issues that need to be addressed. There's also the narcissistic personality. These are clients who, really need to be the center of attention. Everything requires excess admiration. They're very grandiose. They have a sense of entitlement. They can be exploitative. They can't identify with the feelings of others. They may be envious. There may even be malignant narcissism. They only understand their needs ultimately through others. And such clients may react with fury to legal setbacks in their case and routinely threaten to sue even when short delays occur. Excuse me. Just got to plug in the computer. One of the best ways to really figure out if there's a problem in one of these areas with clients is by the lawyer, and I do this, monitoring your own uneasiness. If you feel that your back is consistently up against the wall, that you need to protect yourself and your firm, that you seem to be giving good legal advice, but the client is triggering you, it's an early warning system that something's wrong. The client may even be dangerous or a potential threat, and the lawyer needs to be aware of it as a practitioner for this area. It's something we don't learn in law school. We don't learn in law school how to talk to clients or how to evaluate clients or how to elicit information from clients or how to deal with difficult clients. But this is particularly important for criminal defense lawyers and particularly important for myself as a criminal mitigation expert. Many of these clients in the end demand unrealistic results. The client may find himself ignored by the lawyer because the lawyer becomes overwhelmed and angry and the lawyer reacts. The client may pay a substantial fee and just expect that all things, as I said earlier, are magically positively concluded. And, these are complex legal issues. Many of these clients are so naive and so demanding and so, frankly, crazy in some ways. That is that their ability to think through these problems rationally becomes so impossible that they're not doing their job. That is, they're not helping the lawyer, they're not helping the criminal mitigation expert. The lawyer can really help himself, and this is what I do as a mitigation expert. Allow for clarity of purpose, allow for consistency of counsel, respect and ensure appropriate boundaries, address conflict or ambiguity when it arises and deal with it right there. I had a client recently who seemed upset. I picked it up immediately on the phone in the tone of her voice. And I said, I'm wondering if there's some kind of concern you have, or I'm wondering if there's a question you have. You seem to be hesitant, and I can tell from your voice that you were less than happy with our talk today. And she opened up about something, and we were able to deal with it professionally without her having to hang up the phone and remain angry about it for the next 2 or 3 weeks. Sometimes it can be helpful to have a second opinion, especially from a colleague in the same office. Before concluding a case with a client, make sure that unfinished business has been considered. Careful documentation is important. Self-awareness as a professional. And in some cases, you do have to consult with a mental health expert for many of these clients because they may have undiagnosed psychiatric issues. They may be terribly ashamed of what happened. They won't want to talk about it. They may lash out at those people who are trying to help them the most. Many of these clients have suffered from childhood traumas and abuses. And these clients, while they may be white-collar defendants, they may not have, in some ways, the ability or skills or communication or know-how or adaptive ability or even executive skills to attend to their needs. They may fear authority. There may be all sorts of issues involved. Well, thank you for listening today. What I've tried to provide is an overview of some of the particular issues as it pertains to white-collar criminal defendants for criminal mitigation cases. I guess the main thing that I always take away from these cases is the degree to which these clients are demonized and how we need to truly humanize who they are given their psychosocial histories Hopefully the criminal defense lawyer and mitigation expert works together at an early stage, allowing for the mitigation report to be available for pre-plea purposes, if it doesn't work out, for pre-sentence purposes, and that ultimately the mitigation report will provide not only the prosecutor and judge with a better understanding about the client, but the criminal defense lawyer as well. Thank you. Again, don't hesitate to email me if you'd like a redacted copy of what we've talked about today.